Welcome everyone to TBA Law this morning. My name is Marguerite Burke. I'm a family lawyer and I'm going to talk to you about parenting after separation. Now, hopefully if you're watching this presentation, I can be of assistance to you. You're probably watching because you've got some issues that you want to deal with. So there are two ways to deal with any parenting dispute. One is by trying to sort it out yourselves, and you can either do that over the kitchen table, you can engage a firm like ours, we can assist with negotiations, writing letters. Otherwise, the government has set up family relationship centres, which is a mediation service, and there are trained mediators at that service that will try and keep parenting discussions child-focused, and they will try and assist you in reaching a resolution. That is a voluntary service. There's a fee that you've got to pay. It's a sliding scale, and I think you can get a couple of sessions at that service. If you're unable to reach an agreement about parenting, your only other option is to go to court and ask a judge to make a decision about what parenting arrangements should be made for your family. Going to court should be a last resort, and it's a long and expensive process. So now if you do need to go to court, there is a pathway which involves a compulsory mediation session. If you attend the mediation, they will give you a certificate, and you need to file that certificate when you file your court documents. That certificate must be less than 12 months old. There are exceptions to when you need to attend mediation, and they are generally cover situations of extreme violence, power imbalances, or where the other party, where their whereabouts is unknown or you cannot contact them. So if you do have to go to court, or you are wanting us to assist you with negotiations, I'm just going to talk about the principles that are set out in the Family Law Act and how the court deal with parenting disputes, because this highlights all the relevant issues that may cross your path if you're in the litigation process. Every family law case is different. However, hopefully we will touch on relevant issues pertaining to your particular case. So the Family Law Act 1975 is aspirational for children, and it's always trying to raise the bar and get the best outcome for children, and that's what mediation is about, and negotiation. There is a mantra that all decisions for children must be made in the best interest of those children, and that is in the Family Law Act, and you'll often hear that term. Of course, where you fall into dispute is in those cases where parents can't agree what's in the best interest of the children. So there's a lot of issues that the court have to deal with parenting disputes, and that's what we're going to touch on. So generally there are two main and separate issues parents have to deal with. One is called parental responsibility, and that covers the major issues in a child's life, such as the child's name, the religion, health issues, schooling, and where they live. For a lot of parents that are separated, a lot of those matters will have already been resolved, and they're not what I would call live issues. So in a lot of cases, the parents agree to share the parental responsibility. If you have a court order for parental responsibility, that responsibility is joint, and there's an expectation that you will consult as parents about those major issues. if any issues arise that have to be decided upon. If there is no order about parental responsibility, you each have parental responsibility, but it's not joint. So in most cases, that is not a big ticket item. The main ticket item that people have trouble with is how time is going to be divided between parents. So when the Family Law Act sets out its objects and principles, and these all underpin what the aspirational aspects for outcomes for children are. So the objects in the Act are to ensure children have the benefit of both parents having a meaningful involvement in their life, and a further object is to protect children from physical and psychological harm and being subjected to abuse, neglect or violence. Another object is to ensure that children receive adequate and proper parenting to help them reach their full potential, and ensuring that parents fulfil their duties and meet their responsibilities as parents. So they're the objects, and the principles in the Act set out a series of rights for children. A lot of people think that I'm the parent, I have a right to see my child, I have a right to do this with my child or whatever. In the Family Law Act, parents are not given any rights. It's the children that have the rights. And these rights include the right to know and be cared for by both parents, and the right of a child to spend time on a regular basis and communicate with both parents and other people that are significant in their lives. And grandparents are specifically mentioned. It is the duty of parents to jointly share the responsibilities regarding the care, welfare and development of their children. It is also a principle that parents should agree about future parenting of their children, and that children have a right to enjoy their culture. And there are specific provisions for Aboriginal and Torres Strait Islanders. So you'll see that there is broadly two sets of circumstances that are probably set out on a spectrum. One is where parents are separated, but there are no issues of violence and children are not at risk. And in those particular cases, where there are no risk factors, the court probably has a less onerous task in dividing the time, and we'll talk about how they do that later on. However, where there are issues of risk, harm, neglect and abuse, greater weight is going to be given to ensuring the safety of children. So children's safety will always outweigh children having a meaningful relationship with the other parent. So where there are risk issues, I'll just touch on some of the issues that parents might be facing and where there's a need to protect children. And these could include things such as domestic violence, drug and alcohol abuse, anger management issues and mental health. There are also situations where these are known as alienation cases, where one parent may turn the children against another parent. They're difficult cases, especially as children get older. And as a corollary to that, there are situations where the children are refusing to see the other parent that they're not living with. They're also difficult cases for the court. The court has if you are in court, there is a process that you go through to unravel all of these issues. Most people that end up in court will have two different perspectives and two different stories about what is going on. Those parents that have the same worldview about their children and how they're best to be looked after often don't end up in court. They're the parents that can probably resolve things through mediation. They may need to attend a lawyer for some aspects of negotiation. Where there are issues of violence and harm, a lot of parents start this whole process by having to attend the local court for an intervention order. So where there is domestic violence, often this has been long-term, and there may be an incident which triggers an escalation of that violence, and I think a lot of people are experiencing that now, and often the police are called in, and you may be assisted by the police in applying for an intervention order. And all of those scenarios are very, very relevant to the family court. Intervention orders are made by state courts, and they are concerned about providing protection to people, whereas the family court is a Commonwealth court, and when it's dealing with a parenting case, is concerned about achieving the best outcome for a child. So another issue that parents face are different parenting standards. And this might be particularly so where a lot of marriages and relationships have had very defined roles. Mum, in most families, might be the at-home mum looking after the children, and dad might be the breadwinner. And all of a sudden, after a separation, people might find it very difficult to perhaps let go of the parenting role and have a lot of concerns about how dad is going to look after the kids, where he's never been particularly hands-on. So when the courts are trying to work out what's best for the children, they look at a fairly large picture, and these are called additional considerations. And these are things that you might need to think about when you're trying to work out a parenting agreement, or if you do have to go to court, some of these issues are going to be more relevant than others in your particular case. So a child's views are relevant. Of course, the age and maturity of the child will determine what weight is given to their views. But by the time a child is, say, 12 or 13, and if those views mature, more weight will be given to them. Obviously, if a child says, "I love staying with dad, I get takeaway and can watch TV all night," obviously that's not going to go down too well with any court. They'll look at what relationship the child has had with family members and what the relationship has been. Sometimes there's been a significant separation between separation and then trying to make parenting arrangements for whatever reason. Sometimes one parent might go overseas or travel interstate and then surface years later. They'll look at what sort of participation the parents had in the child's life, the parental capacity, what's going to be practical and workable for that family. The court has to make an order that is going to end the dispute and the litigation. Orders shouldn't be made that are going to result in further litigation. And this is a sort of an open-ended list, so it ends by talking about any other fact or circumstance. So if you do end up going to court, your evidence is provided to court in affidavits, and your affidavit and your application get filed in the court system, and then the other party has to be served with those documents and they can respond. So at the very early stages of the case, the matter may come before a registrar, first, especially in this COVID environment, and a number of procedural or housekeeping rules will be made. If there are urgent issues, then your affidavit material needs to set out what they are in great detail. The courts are fairly overwhelmed with litigation at the moment, and court cases are being delayed and blown out. So to jump the queue, you need to have fairly strong evidence and plead your urgency in great detail. And it's often very, very useful if you can provide medical reports, school reports, or any other material that will strengthen your case. If the case has serious allegations of violence, abuse, or risks to the child, an independent children's lawyer may be appointed. That role is pretty much a forensic role. They don't take instructions from the child. They try to narrow the issues, assist with settlement. They'll subpoena relevant documents, including police, hospitals, schools. They'll speak to teachers, family consultants, assist in arranging psychiatric and psychiatrist appointments for the purpose of obtaining reports. They may request drug screens. They'll meet with the children. They'll ask the children their views. And they have to form a view. It may be a preliminary view during the early stages of litigation, but the court wants to know what their view is on what is best for that child. During the process of litigation, there may be a requirement or a request that the non-resident parent's visits are supervised. That might be where there are allegations of risk, or where the children haven't seen the parent, the non-resident parent, for a long period of time, and they need to get to know them. Now, often there's a resistance to having your visits supervised, and in those situations, I often tell the non-resident parent that, look, supervision isn't going to go on forever. If you pay a private supervisor, you will get the benefit of a report and an objective pair of eyes that can advise the court in their report about your ability to parent, how the children reacted with you, and how the visits went. And even though it may be unpalatable to go down that pathway, it can actually assist in progressing your case. Often there will be a requirement for parents to attend parenting courses or anger management courses, and once again, these requests are often met with a wall of resistance, but I think in most cases these courses can be very useful, and they do, I guess, give the court a certain level of confidence that you are committed to providing the best you can for your children. Often they're seen as a punishment or an indication that you are a bad parent. Agreements can be made to attend these courses without admitting the necessity of it. And motherhood statements can be made about why you attended those courses. Sometimes parents complain that their children are very unsettled after visits, And that's especially so in high conflict cases. And in my experience, that is a very common reaction for children. And it doesn't mean those children are being abused or neglected. Obviously, there are some cases where the visits are not working for children. However, the fact that they are unsettled is not always conclusive that is the case. So, especially where there's been a gap with the parent or the children are very tuned into the stress and the conflict that's going on in the family. Now, if during the court case, the court will generally seek the assistance of a family consultant early on in the case. They can have a mini report just to try and unravel the dynamics of what's going in, because what you have to realise is that a judge doesn't know you. They're faced with two sets of documents, quite often crafted by a lawyer. And so a family consultant is brought in to try and give some greater depth to what is actually going on in that particular family, and to try and assist the judge in creating a safe pathway forward in resolving the parenting dispute. If the matter proceeds to trial, then a full family report will be ordered, and that is a very extensive document. The family consultant will have the benefit of reading all the court file documents, all the subpoenaed material, and will spend a lot longer with the parties separately and with the children separately, and then the children with one parent and then the children with the other parent. During the court case, where there are allegations of drug abuse, orders can be made for the provision of supervised random drug screens so that issue can be addressed and monitored throughout the case. There may be orders for psychiatric or psychological reports, and that's especially so where there are mental health issues. Generally, as the case is progressing through court, orders will be made during the progress of the case to respond to the issues as and when they arise. During the case, interim orders will be made, and they will be both housekeeping orders about filing documents, attending reports, drug screens, etc. But there will also be orders about how time will progress and how the decisions and who will make the decisions will be made. There are significant delays in reaching a trial, and you may be waiting a couple of years. I've been in cases that have gone on for 5 years, and they were for very significant reasons. And it's not always because the court is delayed. Sometimes a lot of materials need to be obtained during the court case, as I said, to respond to new situations that arise. And sometimes you spend a year on a case and then something will occur which will set you back, and there can be many ups and downs in the litigation process. Cases that do end up going to trial often settle on the day of the trial. Cases that run to trial are very stressful. You will be cross-examined on the evidence you have given, and depending on the length of the case, a lot of the cases are very expensive to run. Witnesses have to be called and subpoenaed, and even during the case, Sometimes the parties, after hearing some of the evidence, will be asked to step outside and see if they can settle it. Of all the cases in the litigation process, only about 5% end up with judges making orders. Now, if orders are made, then you have an enforceable agreement that will set out what is to happen in your family. I'm just going to touch on the COVID situation. If you've got court orders and you don't comply with them, the issue will be whether you had a reasonable excuse. COVID for restrictions of themselves are not a reasonable excuse to breach, not to comply with an order. The 5 kilometre rule does not apply, but if you have court orders or parenting plans, you should have them with you when you're travelling to and from the visits. A reasonable excuse would be where the child is ill or where somebody in the household has contracted COVID or is going to a home where someone has it. You would want medical evidence to support that. The family court has a specialist COVID list, which is very quickly accessed, and you need to prepare material that addresses the issues required for you to access that list. If you do have court orders, you can only bring a contravention application if those orders are less than 12 months old. If they're more than 12 months old, you need to go back to mediation to enforce them. So there are many, many hurdles and complexities in going to court, but those cases where there is conflict and risk to children are those sorts of cases that generally now end up in court. So I think that just pretty much takes us to the end of this session. As I said, I'm a family lawyer with TBA Law. Please feel free to contact me if there's anything in today's presentation that you'd like further clarified, or if I can be of assistance to you in your any issues that you're experiencing in parenting after separation, especially in these very, very difficult times. I just wish everyone the best, and hopefully we will all get through this period, and the pressure cooker situation that it's placing families in, especially where people are working from home and caring for children in the home. So I think we'll finish it there, and thank you all for listening to me, and I hope this has been of some assistance to you. Thank you.